Good afternoon, everybody. It's great to see so many people have joined us today. Welcome to today's webinar, Where Does the Buck Stop? Liability for Licensing and Property Standards in HMOs. My name is Tamanna Begum, and I'm a Housing and Property Disputes Paralegal at Anthony Gold Solicitors. We are joined by an expert panel of lawyers, and many of you would have already worked with them before. We have Robin Stewart, who is a Senior Associate Solicitor at Anthony Gold Solicitors, Archie Madden and Dale Timpson, who are barristers from Five Pump Court Chambers. Right. Before I introduce you to the speakers in more detail, I would like to say that we are very pleased to be holding this joint webinar with Five Pump Court today. Anthony Gold has worked with barristers from Five Pump Court for many years now, particularly in criminal and tribunal proceedings relating to HMOs and property licensing. Our speakers today will be sharing the benefit of their years of experience of advising landlords, letting agents, local authorities, and tenants on the areas of law that they will discuss with you shortly. This joint event allows us to share a unique range of perspectives on the rented sector, and we hope that everyone joining this talk today will benefit highly from it. So our first speaker is Dale Timpson, and he specialises in all areas of property disputes, including criminal prosecutions. He recently represented a leaseholder before the upper tribunal in an appeal which gave important guidance on the proper approach to be taken by the tribunal in a rehearing of an HMO licence application made by a relevant person. Today, Dale will be discussing the factors under Section 44, subsection 4 of the Housing and Planning Act 2016, and how tenants' conduct can affect the level of the RRO award. We will also discuss tenants' liabilities for breaches of the HMO management regulations. Secondly, we will have Robin Stewart, who is a specialist solicitor in HMO law, and he represents private residential landlords and letting agents in prosecution proceedings and civil penalties. He has acted for landlords in proceedings relating to HMOs in the upper tribunal and the Court of Appeal. He is also involved in advising students with legal problems relating to private sector tenancies, and in that capacity, he also assists them, or he assists tenants with making applications for rent repayment orders. Robin will take us through the defence of reasonable excuse and recent decisions from the upper tribunal on the liability of private landlords and agents. Finally, we have Archie Madden, who will already be known to many of you as the leading barrister in this field. He has particular experience in representing local authorities and private landlords, and has been involved in several important upper tribunal cases relating to the Housing Act 2004. Archie worked in-house for a local authority for several years and was instructed by a London borough in a series of prosecutions and appeals relating to HMOs owned by a landlord who was described by The Guardian as being Britain's worst landlord. Today he will be discussing the impact of the Court of Appeal's decision in the recent case of Rakusen versus Jepson and the liability of superior landlords. Just a few more things before we get on with the talk. There will be a Q&A at the end of the webinar, so do continue to stay tuned. Please feel free to leave your questions using the question box available at the right-hand side of the screen, and we will try and answer them as much as possible at the end of the webinar. If there are any technical issues during the webinar, please let us know by sending us a message using the chat function. There are also slides available. You can download them now by clicking on the handouts option in the bottom right-hand side of the screen. We are also recording this session, so the recording and a copy of the PowerPoint presentation will be available to you shortly after the webinar. I will now pass over to Dale, who will discuss tenants' conduct in calculating RRO awards and tenants' liabilities in breaches of management regulations. Thank you very much for attending, and over to you now, Dale.
Hello, good afternoon, and thank you again for joining us. I'm going to be kicking off this afternoon's discussion considering tenant liability, and I'm going to be dealing with two distinct aspects of that. So first, I'll be dealing with tenant conduct as a factor in quantum for rent repayment orders, and secondly, I'll be dealing with blaming tenants for breaches of the HMO management regulations. I'll then be handing over to Robin, who will take you through all matters relevant to the liability of agents and others. So starting with rent repayment orders and tenant conduct as a factor in quantum. By way of background, we've got section 44, subsection 4 of the Housing and Planning Act 2016. And this sets out 3 specific factors which the tribunal must in particular take into account when determining the amount of a rent repayment order. We can see in subsection 4A that one of those is the conduct of the landlord and the tenant. So I'm going to take you through some recent cases which consider conduct of the tenant in determining the amount of a rent repayment order. But it's important to note at this stage, with section 44, subsection 4 in mind, this isn't an exhaustive list. Other relevant matters can be taken into account that are not on this list, and that was recently confirmed by the Chamber President, Mr. Justice Fancourt, in the case of Williams and Palmer, which I'll be coming on to in due course. Now, the first case I'm going to look at is Wilson and Campbell. This isn't a very recent case, but I wanted to raise it because it's an important one not to forget. Ultimately, in this case, the upper tribunal made clear that the first tier tribunal shouldn't be making adverse findings about any alleged misconduct of a tenant who's applying for a rent repayment order without conducting a hearing, and importantly, giving the tenant the opportunity to respond to allegations that are being made about their conduct. The same principle must also apply to landlords' misconduct, insofar as if allegations are being put forward, the tribunal must hold a hearing and be able to test those allegations. So it's important to always remember that if there are issues which go to conduct either of the tenant or of the landlord, parties shouldn't be agreeing to paper-based determinations, and parties should be attending the first tier tribunal hearing prepared to put the allegations of misconduct to the other side. So with that in mind, I'm going to move and look at some recent cases which consider tenant misconduct. The first is an upper tribunal decision of this year, Cowlek and another, and Hassanain Limited, which was a case where the first tier tribunal awarded a reduction from the maximum figure of 50%. And this was mainly due to significant rent arrears. Now, eagle-eyed participants may note that there's a £2,000 difference in the sums that you can see on screen. That was due to a £2,000 difference in rent being paid outside the relevant period. So the maximum figure in terms of rent for the relevant period in this case was £23,819.98. Now, so the tribunal awarded a 50% reduction, the tenants appealed to the upper tribunal, and the upper tribunal effectively upheld the 50% reduction. And there were 4 important points which were stated by the upper tribunal in this case. The first was that no limit is imposed on the type of conduct that may be considered. The second, there is no detailed guidance given about the significance or weight to be attributed to different types of conduct. The third, there is no reason why relevant conduct should not include the conduct of the tenants in relation to the obligations of the tenancy. And fourth, failing to pay rent without explanation is a serious breach of the tenant's obligations. So the upper tribunal affirmed in that case the 50% reduction to the maximum figure as a result of significant rent arrears. The next case, Awad and Hooley, was another upper tribunal decision of this year. And it was another case involving rent arrears, which were significant. But there were some other factors in play in this case, which led the first tier tribunal to award a 75% reduction from the maximum figure. So not only were there rent arrears, the tenant had failed to allow an electrician entry in order for the landlord to obtain an EPC, and the tenant had cancelled other pre-arranged visits. It's important to note that there were some mitigating factors present on the part of the landlord. The tenant in this case appealed again to the upper tribunal and said that 75% was too much. But one of their main grounds of appeal was that the tenant's conduct insofar as their rent arrears and the tenant's conduct in not allowing entry to the premises weren't relevant because they argued it didn't aggravate or mitigate the offence. In other words, for example, what they said was their failure to pay rent had no effect on the landlord not having a licence for the HMO in the first place. The upper tribunal dismissed that and upheld the 75% reduction, and they expressly found that the conduct did not have to have an effect on the offence itself. The upper tribunal also stated in that case expressly that whether or not the maximum is described as a starting point, clearly it cannot function in exactly the same way as a starting point in criminal sentencing. And the upper tribunal also noticed that it would be unusual for there to be absolutely nothing for the first tier tribunal to take into account under section 44.4, again reiterating that the statute gives no assistance as to what should be ordered. And the tribunal said that nor could the tribunal in that case in the absence of a suitable appeal. So therefore, in that case, the upper tribunal seemed to be paving the way for a suitable appeal in order to give guidance on those factors. And that may well have been the next case which I'm going to turn to consider. Because what we recently have is the case of Williams and Palmer. This was a decision handed down a few weeks ago by the Chamber President, Mr. Justice Fancourt. And the upper tribunal first noted that the words of section 44 left open other factors that may be taken into account and affect the amount of the order. So this is what I was referring to earlier when I mentioned that those three factors listed in section 44.4 were not an exhaustive list. There are anything else which is relevant the tribunal can take into account in deciding whether there should be any reduction or not. Importantly, the upper tribunal in this case stated that the amount of rent paid in the period is not a starting point in the sense that there's a presumption that the maximum amount is what is ordered, subject to those factors in section 44.4. And that's specifically important with regards to what Mr. Justice Fancourt said at paragraph 26, because what paragraph 26 of this decision has the effect of doing is rolling back what was frequently taken from the upper tribunal's decision in Maddan and Stewart, confirming that the maximum amount of rent is not to be ordered, subject only to limited adjustment for those factors in section 44.4. And as I say, that's likely to have a significant impact on the sums now ordered in rent repayment orders. Since Maddan, the maximum rent paid has generally always been the starting point, and that is no longer so. So that's an important decision, as I say, very recently, that parties should always take into account in determining the amount of rent repayment orders. Finally, I'm going to move on now and discuss blaming tenants for breaches of HMO management regulations. Now, as a starting point, we can see that section 234.3 of the Housing Act 2004 makes a failure to comply with the management regulations a criminal offence. Regulations 3 to 9 impose duties on the manager of the HMO, and these can be as far and wide-reaching as anything from not displaying notices in the HMO which contain the landlord's name and contact details, all the way through to much more serious breaches, such as fire safety, including not having smoke alarms, fire doors, etc. Regulation 10, importantly, imposes duties on the occupiers of the HMO, including, importantly, conducting themselves in a way which will not hinder or frustrate the manager, and to allow reasonable access to the landlord. A full list of those duties for the occupier contains in Regulation 10. You can see there on screen. Now, what's the effect of this in terms of blaming tenants for breaches of the HMO management regulations? Well, points to note are as follows. First, it's much more difficult to blame tenants for breaches of the HMO management regulations. There's no automatic or express reduction in any sanction for tenant conduct in the same way that there is in section 44(4) of the Housing and Planning Act, which we just looked at for rent repayment orders. Neither are there any reported cases that I'm aware of involving any prosecution of a tenant under Regulation 10. But that said, it may be that breaches of Regulation 10 by a tenant can constitute a reasonable excuse for the landlord, such as not being allowed access to the property to inspect or carry out works which need to be done. And going back to rent repayment orders, just very briefly on this point, it may be that instead of just alleging tenant misconduct for matters such as failure to allow access, as we looked at earlier, in order to reduce the award, in my view, there's absolutely no reason why that tenant misconduct cannot be put forward on the basis that it's a breach of Regulation 10 in an appropriate case to further strengthen the case for a reduction to a rent repayment order. Now, given that there is no guidance on weight to be given, my submission in an appropriate case would be that more weight should be attached to tenant misconduct if it amounts to a breach of Regulation 10. But going back to the management regulations, the final thing that I'll say is there haven't been any recent cases on the management regulations in the upper tribunal. So there's no cases to discuss in respect of this. But I'll take the opportunity to remind all landlords, agents and their advisors that the management regulations place positive duties on the managers of HMOs. There's no express duty to inspect, but that comes about by way of the duties themselves. If managers are not regularly inspecting, they're leaving themselves wide open to breaching the regulations. So a regular inspection regime is important for all landlords or managers of the properties to have in place to ensure that they're complying with the regulations. On that note, I'll now hand over to Robin, who will discuss blaming the agents and others.
Thanks, Dale. The loose theme connecting all of these talks is about shifting the blame or shifting responsibility, or situations where situating the legal liability is in some way complicated. And so where my talk starts is thinking about blaming the agents and blaming others. And by others, I really mean anyone other than the tenant, since Dale has covered that. I'm not talking about contractual disputes between landlords and agents today. I'm not talking about professional negligence claims. We're looking at a regulatory context where landlords might want to rely on a reasonable excuse defence, which might involve blaming someone else, or where, as part of mitigation, damage limitation, they might be blaming another party, or where landlords are trying to say, even if they have committed an offence, no punishment should be imposed because it's not in the public interest to do so. So this is the context where I'm talking about blaming agents and other parties. I'm going to run over a few of the more interesting cases looking at reasonable excuse in particular, for those less familiar with the regulatory framework for licensing, it is a defence for a landlord or an agent who is being prosecuted or fined or facing a rent repayment order if they can demonstrate that they have a reasonable excuse. That applies to all of the licensing offences. It applies to breaches of the management regulations, which Dale was just talking about. Sorry. So why agents and others? Well, recent case law has picked up on a few situations where local authorities have given the wrong advice to landlords, and that has given rise to an excuse. The focus of this talk and the focus of a lot of the recent case law is landlords who don't know or don't fully understand their licensing obligations, and that can be because they've been given wrong advice by someone. None of the cases I'll touch on directly address wrong advice from a lawyer, but there's no reason why others couldn't extend that far. I've listed the cases there, and that's available on the slides, which you can download if you want to look up the references to any of these cases. The first I wanted to talk about today is Thurrock and Dowdy. This was a appeal against a civil penalty for £10,000 for managing and having control of an unlicensed HMO. The local authority imposed a penalty of £10,000. This was quashed on appeal by the first tier tribunal, who said it was not reasonable or appropriate to impose any financial penalty in the circumstances of this case. They didn't do so because they found that there was a defence. They found that there wasn't a defence, but the circumstances were such that no penalty should be imposed whatsoever. And the upper tribunal disagreed with that on appeal by the local authority, but didn't agree to uphold the full penalty and settled just under the middle at £4,000. The first tier tribunal's reasoning for quashing the penalty entirely was that they thought that the threat of prosecution or a penalty had served its purpose. After the threat of regulatory action was made, the landlord applied for a licence and did so reasonably quickly. And in those circumstances, they said the penalty itself was unnecessary. That was found to not be a relevant or a relevant factor to not impose a penalty. It was, however, a significant mitigating feature, and so really that's how the result was reached. Thurrock and Dowdy is, I think, interesting for its discussion of ignorance generally. The tribunal identifies that where a property isn't licensed, because it wasn't realised that it needed to be licensed, there's two ways which that can come about. Ignorance of the facts, so the landlord is not aware of the circumstances which have made the property require a licence, or ignorance of the duty to have a licence at all. And there's a comment in this case that it would be difficult for a landlord to defend a case if they haven't taken reasonable steps to stay aware of their obligations, if it's a ignorance of the law type defence, ignorance of the need to have a licence. So I think this sets the scene for ignorance cases generally. It is, the tribunal says, possible to conceive of circumstances where the landlord has a reasonable excuse for not appreciating that a property has come within a selective licensing regime. That is, I would suggest, when looked at in the context of the judgment, a reference to a landlord being unaware of the need for a license, being unaware of their legal obligations, and this is where this reasonable steps idea is introduced. And so that was an upper tribunal case. There's one High Court case to mention today, and this is Mohammed and London Borough of Waltham Forest. This was a judicial review arising out of a prosecution. The landlord raised 3 big technical arguments, and I'm only mentioning one of them today. So certainly this was a bold effort to see off a prosecution. The landlord had argued that there was a mental requirement, a mental element to the offence of managing or being in control of an unlicensed HMO. And they were arguing something quite novel. They were saying that the offence was not really a strict liability offence, and that there was a mens rea element to be proved by the prosecution. In law school, I was taught that it was very important that we retained legal Latin. We were taught that was a way to keep the clients feeling like they needed our help. And so in that spirit, I'm going to use the phrase mens rea. It essentially means guilty mind, and it's a criminal law concept. In many criminal offences, it's a requirement for the prosecution to prove that the offender knew what they were doing, knew that they were doing something wrong, intended to do something wrong. And the orthodox position has been that that is not part of the managing an unlicensed HMO offence. This argument was entirely rejected. 6 reasons were given, plus a bonus reason, really. I'm not going to run through them all. It's all in the judgment if you want to see exactly why. But this argument was comprehensively rejected. In my opinion, Mohammed doesn't really develop the law. It's more a confirmation of the mainstream interpretation of the legislation. I think that's a pretty uncontroversial view. So if the landlord had been successful with this argument, it would suggest that every prosecution that had taken place for years in the magistrates' courts had been done on a misunderstanding of the law, and that was rejected. Does this case tell us very much about what is or is not a reasonable excuse? I would say it does just a little. One of the reasons why the High Court was willing to say that there should not be a intentionality or mens rea element implied into the offence of managing an unlicensed HMO was that there is a reasonable excuse defence. And so if a landlord unknowingly commits this offence, they can have an offence if they have good enough reason for that. And what's interesting is the High Court also used this term reasonable steps. They said that the objective of the Housing Act 2004 was to ensure that those who control or manage a property which is an HMO take reasonable steps to ensure that their properties are registered as HMOs where necessary. So that phrase cropping up again, it's not in the legislation, but that's 2 courts, or a court and a senior tribunal, both expressing a very similar idea about what is actually required of landlords. They're required to take reasonable steps. Many strict liability offences don't have any reasonable excuse defence of this type, but in housing law, we do tend to find that. I think it's notable that in some areas of housing law, we have true strict liability, where the landlord's knowledge or ignorance of their obligations or the circumstances don't really make a difference. And one example of that is with the tenancy deposit protection rules. If a landlord fails to protect a tenancy deposit, they face a non-criminal sanction. They'll have to pay the deposit back, and they'll have to pay a penalty of between 1 and 3 times the deposit. It might not be criminal, but that's a sanction, and it's strict liability in the sense that the landlord will have to pay something, whether they have an excuse or not. So it can be frustrating for tenants applying for a rent repayment order that they don't have the same guaranteed payment that a tenant seeking a deposit penalty would have. And that's a function of the reasonable excuse defence, meaning that these strict liability offences are not as strict as some other types of sanctions, even if the bar is high. Thurrock have been busy. My third case is Thurrock and Palmview Estates, and this addressed a small technical detail. The upper tribunal stressed in this appeal that reasonable excuse was not reasonable excuse for not applying for a licence. The defence was actually having a reasonable excuse for managing and controlling an unlicensed property. So it's not focused around the reasons for not applying for a licence. It's focused around having a reasonable excuse for continuing to manage. That mattered in this case because the local authority had suggested that applying for a licence would be a waste of time. Planning permission wasn't in place and wasn't going to be, and so any application was going to be rejected. The FTT, says the upper tribunal, asked themselves the wrong question when they asked, was there a reasonable excuse for not applying for a licence? Their conclusion had been yes, on the basis that the local authority had said any application is going to be refused, and the upper tribunal said that had led them into error. I think this case is interesting for agents, in as much as agents will sometimes find themselves in a position where they are managing because they are collecting rent, and they are unable to apply for a licence because they don't have authority from the landlord to do so. The effect of Thurrock and Palmview Estates might be that even where an agent has a very good explanation for why they can't apply for a licence, continuing to manage the property is a problem because they might not have an excuse directly for that. De Costa and De Andrea brings us into rent repayment orders. This was a rent repayment order brought by tenants in respect of another failure to hold an HMO licence. The landlord appealed against the rent repayment order that had been made. She said that she had been told by a council employee in an email that her property was originally not eligible for a licence, and that she was told that should the position change later and the property needed a licence, she would be told. The position did change because changes to mandatory licensing in 2018 meant that more properties required licenses, but the landlord didn't find out about this and no one from the local authority did contact her. The First Tier Tribunal accepted that Mr. Costa genuinely believed that she would be told by Tower Hamlets even when a licence was required. On appeal, the upper tribunal found that this did amount to a reasonable excuse, and it was difficult to understand why a landlord would not have a full defence in those circumstances where a local authority employee has given such an assurance. Similar issues to De Costa arose in a First Tier Tribunal case concerning property guardians. In that case, an email had been sent from Croydon Council to the property guardian company, and they had confirmed their view that the property was exempt from licensing. This is a first tier case, but it's interesting on a lot of levels. And the judge in this case held that there could be no better excuse than the local authority saying expressly that no license was required. And so no rent repayment order could be made in that case. So De Costa deals with advice from the local authority or an assurance from the local authority that advice would be given. Do the same principles apply to letting agents and to lawyers? I think this is something which the upper tribunal will be focusing on soon. Local authorities clearly do have a slightly special role as an enforcement body and a regulator. And so it's possible to say that they're in a slightly different category to letting agents and lawyers who advise landlords. This is certainly something which the upper tribunal will have to grapple with soon. And indeed, in Equiosa and Redbridge, this did partially have to be dealt with. This was an appeal brought by a landlord against the decision of the first tier tribunal to uphold a £2,500 civil penalty for an offence under section 95. This was a failure to hold a selective licence in Redbridge. The landlord was abroad. She was unaware of the need for a licence, and she had a managing agent based in the UK. Now, Redbridge's enforcement policy said something quite interesting. It said, should an informal approach fail to prompt action by a property owner, then the next stage will be statutory action. So what this suggests is letters will be sent, and if that doesn't get the job done, then formal powers under the Housing Act will be used. And obviously, a civil penalty is statutory action. The landlord in this case made an application for a licence 3 weeks after the first contact, and so reasonably quickly in the upper tribunal's mind. In this case, the upper tribunal held that the appropriate disposal was no penalty at all. Reasonable excuse wasn't actually directly raised by the landlord in this case, and so it wasn't directly tackled. But the upper tribunal was comfortable with the idea of imposing no penalty at all, and the basis for that was it seemed consistent with Redbridge's policy and the government guidance to encourage landlords, especially those who live abroad, to engage professional agents to act on their behalf. It's interesting that the first case I mentioned, Dowdy, involves the upper tribunal overturning a decision to impose no penalty, and Equiosa, my last case, involves the opposite way round. The upper tribunal decides no penalty is the right conclusion. But it's clear they are quite different cases. I think the facts for the landlord are much more favourable in Equiosa. Certainly, the landlord being abroad and unaware, being abroad seemed to count quite strongly. But also, the upper tribunal felt that Redbridge's own policy hadn't been followed properly, and that was part of the rationale for taking no formal action. There is an interesting comment on reasonable excuse towards the end of this judgment. The tribunal had accepted that the first tier tribunal had accepted that the landlord had delegated her responsibility to her agent, but concluded that this did not divest her of her statutory liability. The tribunal noted that, but decided not to tackle that head-on in that decision. So it's clearly been flagged as something which the upper tribunal is interested in. They're interested in the extent of agents' duties and the extent to which a landlord can rely on that. Just to take some practical points out of that overview, if in doubt, landlords and agents should be asking for advice from the local authority, because that will be helpful in its own right and can provide the basis for a defence later. And obviously a record of that needs to be very carefully kept. There's a theme emerging that the tribunal is interested in the policy objectives of the Act and seems to be actively encouraging landlords to engage agents, especially when they're abroad, but it's not yet clear how far that goes as a defence. That said, there does seem to be an emerging idea of landlords taking reasonable steps as a requirement to fulfil a defence, which is slightly a slight gloss on the reasonable excuse defence set out in the statute, but perhaps easier for landlords to get their head around. Where landlords place the blame on a local authority for giving the wrong advice, that clearly can amount to a full defence. And as I said, issues are there to be explored about advice from agents. Very different issues arise when we're looking at agents' obligations in contract and in negligence towards their landlords. It's a separate issue which deserves a talk of its own. But the reason I wanted to mention that is all of this focus on blaming another party in order to create a reasonable excuse defence will inevitably bring up issues of negligence and negligent advice, which will be relevant to agents. So that was what I wanted to say about blaming agents and others, and I will now hand over to Archie for the third talk.
Thank you, Robin. The matter that I'm going to be picking up on here is a case which I'm sure all of you are very well aware of. But a bit of background first. The changes brought by the 2016 Housing and Planning Act Part 2 to rent repayment orders have led to a considerable increase in RRO applications being made. And I'm sure that many of us, including those of you watching this presentation, have found that we're confronted more and more by RROs, and it's clearly a relevant live area. Now, this growth has led in turn to a number of judgments in the upper tribunal and now the Court of Appeal, clarifying the legislation and the correct approach to be taken by first-tier tribunals when they are hearing rent repayment order applications. The last 2 years in particular seem to have been something of a roller coaster at times, with appellate decisions seeming to at first favour applicants, the tenants, and then latterly now beginning more to favour landlords and others who are defending such applications. This evening I'm going to briefly discuss the really important Court of Appeal decision handed down on the 29th of July that considerably restricted the scope of those who can be subject to rent repayment orders and made to repay rent to tenants. And that's the case of Rakusen and Jepson. Prior to the Court of Appeal decision in Rakusen and Jepson, the upper tribunal had ruled that all landlords with an interest in a rented residential property were in theory capable of being ordered to repay rent to occupying tenants if the required elements of an RRO were made out. Now, this was made clear in the case of Goldsborough and Gardner, a 2019 case. And the upper tribunal hearing in the case of Rakusen itself clearly followed the line which had been established in 2019 in Goldsborough and Gardner. Now, this line of upper tribunal decisions in practice meant that tenants and those advising them who were seeking to apply for a rent repayment order could make the application against all and any landlord parties, starting with their immediate landlord, their immediately contracted landlord, up the scale and pyramid of tenure, up to the owner of the freehold or the long lease reversionary interest. This situation was clearly of importance given the development of the rent-to-rent market over the last decade or so, where we have a situation with often multiple landlords renting to subordinate landlords in a chain that ultimately ends with the actual occupying residential tenant. Now, the situation which was established in Goldsborough and Gardner clearly suited tenants in practical terms, who were seeking to recover often substantial amounts of rent, since they had a richer field of targets to bring their applications against. And this meant that RROs were being obtained against senior landlords who had actual assets, rather than often sub-landlords who frequently are holding little more than a short-term lettings lease with a right to sublet to actual occupants. And that, of course, is in essence what the rent-to-rent market in many parts of the country has ended up being. Now, the reverse, of course, in terms of opportunity, if you like, was naturally true for superior landlords, who often were arm's length, but found themselves suddenly liable to repay rent, which they themselves had never received, or even for infractions which they themselves were not responsible for. And this gave rise to much comment from all the different stakeholders and players in this field of RROs about, on the one hand, the perceived unfairness of tenants being able to obtain rent back from persons who were not their immediate landlords. And in the counterpoint, comments being made that limiting RROs to immediate landlords would allow for deficient landlords to evade the consequences of their actions and even to subvert the purpose of the legislation by putting further layers of tenure between themselves and the actual tenants, who of course are feeding the money into the pyramid. This of course has all been heightened by the fact that the substantial increases in rent being charged, particularly in big cities such as London, has meant that now we have quite large amounts of money at stake, and often also, obviously proportionately, very important sums of money for the tenants, who in many cases can be paying many hundreds of pounds a month simply for a room. And the total amount that we can be dealing with in RRO cases is frequently, in my experience now, many tens of thousands of pounds. And I've indeed just dealt with a case which was, for 1 year, over £40,000 was at stake. And these are clearly substantial amounts of money on any basis. And landlords clearly were at considerable risk. Now, turning therefore to the case of Rakusen and Jepson in July of this year. The first thing to note is that the Court of Appeal, in looking at that case, put to one side all of these sort of policy considerations. And what their lordships actually did was carry out simply a detailed examination of the wording of the relevant statutory provisions. And the headline of this is that they concluded that, in fact, it had never been the intention of the statute to extend liability for RROs beyond the immediate landlords of occupying residential tenants. In effect, they overturned the Goldsborough line of argument and authority. Now, it's therefore necessary for us briefly to look at this rather perhaps dry statutory analysis which the Court of Appeal carried out to properly understand how we've ended up in this situation. And I'm therefore going to simply leave up on the screen the relevant, most important part of the 2016 Act, which was really under examination by the Court of Appeal in the case. I won't go through it in enormous detail because it's going to be better for anybody interested to simply read the case, but I'll give you the headlines of it. Now, the case itself, Rakusen and Jepson, involved the owner of the reversionary interest in a flat on the Finchley Road, that's Mr. Rakusen, who had let the entire property to a company called Kensington Property Investment Group. And that was let by him on a 3-year lease, which permitted subletting of all or part of the flat to residential occupiers. In essence, it's an absolutely standard rent-to-rent type structure, which many of you will have encountered. Now, in turn, the rooms in the flat were rented out to unrelated individuals, thereby creating a house in multiple occupation that in turn required a license that of course was never obtained, hence giving rise to the grounds for a rent repayment order. It's a straightforward non-licensed property RRO case. Now, the tenants made an application for a rent repayment order against Mr. Rakusen, who of course you'll recall is a superior landlord. And this was granted by the first tier tribunal and upheld on appeal by the upper tribunal, taking into account their previous decision in Goldsborough and Gardner in 2019. Now, Mr. Rakusen, in this case, appealed on up to the Court of Appeal, and it's that decision which has changed the law. Now, his appeal, boiled down, consisted of the simple contention that the statutory provisions of the 2016 Act did not actually permit a rent repayment order to be made against a superior landlord such as him, but that the only person against whom such an RRO could be made was the actual immediate contractual landlord of the tenant making the application. Now, the Court of Appeal, the first judgment was delivered by Lord Justice Arnold, and he examines the provisions of the 2016 Housing and Planning Act, the ones that are on screen here. Now, his reasons for finding that only immediate landlords can be subject to an RRO were broadly as follows. Firstly, the wording of section 42A refers to, quotes, the landlord under a tenancy of housing. Now, that is crucial because that phrase is key to both of the judgments in the court's decision. Now, in the case of Lord Justice Arnold, he concluded that this could only mean the direct landlord in a tenancy held by a tenant, i.e. the occupying tenant's actual immediate landlord. And the judge cites with approval the submissions made on behalf of Mr. Rakusen that the wording of section 42A referred to only one tenancy and hence could only encompass one set of contracting tenants and a landlord, which in this case, of course, were the ones that were party to that individual tenancy agreement. The key to understanding the provisions was that they referred to a single identifiable tenancy to which the applicant tenant was a party. This in turn allowed for a single immediate landlord to be identified. And if you're interested, you will find the comments there by the judge at paragraphs 23 and 25 of the judgment. Now, in addition, Lord Justice Arnold identified the use of the word repay in section 42A as more naturally referring to the return of rent previously paid by a tenant to the landlord who was making the, quotes, repayment, rather than a payment being made by an unrelated third-party landlord further up the chain of tenure, which of course would be in relation to rent which he himself had not previously received. So that reference, that discussion, you'll find at paragraph 27 of the judgment. Now, Lord Justice Arnold then did further consider the difference between section 42A relating to claims by tenants for rent repayment orders and the accompanying mirror section at section 42B, which governs claims for rent repayment orders made by local housing authorities who are seeking to recover universal credit payments made for rent. And when one looks at the wording of section 42B, if you like, the housing benefit provisions, it clearly excludes superior landlords from being the target of claims by local housing authorities. And yet, there's no obvious reasons why local housing authorities should receive different, less generous treatment under the Act than private tenants. And the correct conclusion, therefore, was that both types of applicants should be limited to being permitted to make applications for RROs only against their immediate landlords, or in the case of local housing authorities, the immediate landlords of the claimant and recipient of the benefit. And that discussion is at paragraphs 28 to 31. Now, the court finally, Lord Justice Arnold's judgment, considered but disregarded a number of points raised by the tenants regarding the wording of the provisions. And I won't go through those in detail. But one thing which does stand out, which I think is of importance, is that the court was invited to consider the wider policy considerations in relation to what perhaps we've come to know as, quotes, rogue landlords. And also within the context of the general condition of the private rented sector as it is at the moment. However, Lord Justice Arnold, whilst explicitly recognising the importance of these issues, expressly avoided such territory and he limited himself to observing that Parliament had legislated only to permit tenants to make claims against their immediate landlords. The judge commented upon concerns that the purpose of the legislation could be neutered in relation to rent-to-rent structures by observing that if that was a problem, then Parliament could amend the section, that is section 40. Finally, his lordship, Lord Justice Arnold, adopted the alternative long stop position put forward by Mr. Rakusen, that in the case of unclear statutes, legal provisions should be interpreted so as to avoid penalising persons under unclear law. So it was pretty clear that upon any of the matters that were being considered by Lord Justice Arnold, he came down firmly in favour of the appellant, Mr. Rakusen. Now, the second judgment was given by Lady Justice Andrews, and it's a very elegant set of arguments presented by her ladyship. She also adopts a strict approach of basing her findings solely upon the meaning of the wording of section 40, subsection 2. And Lady Justice Arnold's based her analysis of the provision upon an understanding again of the term, quotes, the landlord under a tenancy of housing. And I would invite you to read her elegant analysis of the meaning of that term, because it provides a single and consistent meaning to both the private tenant and local housing authority parts of section 40, subsection 2. So that was very clear that the Court of Appeal have now limited the liability to immediate landlords. And so what should we take away from this? And these really on the screen now, we've just got some thoughts which I have about where this leaves us. Firstly, I understand, as far as we can tell, because I'm not personally involved in the case, that there is an application for permission pending for appeal to the Supreme Court. And my understanding is that that has not yet been determined. And so it is possible that this case will go up to the Supreme Court at some point in the next few months. But pending that permission decision for appeal, we are then in a situation where the first thing that we can clearly say is that rent repayment orders, if they're to be made or pursued, existing ones, should only now be pursued against immediate landlords who are the actual contractual landlords of tenant applicants. Secondly, that clearly will have an effect upon if you like, the tactics which will be employed by applicants and those who advise them and represent them when they start a claim. The most important thing is it worth bringing the claim? As I've mentioned earlier, we have a problem of assetless rent-to-rent landlords, and this is by its very nature inevitable because of the rent-to-rent market. Effectively, people hold merely often a short-term lettings lease. And I've represented such landlords, and I'm sure many of you have advised them. There's nothing per se wrong with it. It's a perfectly legitimate and legal form of tenure structure. But in practical terms, it means that those applying for rent repayment orders could end up effectively with empty judgments, which they can never enforce. Thirdly, I think one then has to think in more detail about these rent-to-rent structures and the arm's length ownership of landlord companies. Those advising landlords may, of course, wish to think about employing such structures to effectively put a firewall of liability between their clients who have valuable assets and tenants. In terms of how that would work, I haven't given a huge amount of thought to that. But I'm quite sure that one might be looking at corporate vehicles. Counter against that, of course, is the considerations that will now be made by tenants and those who advise them. I know that there is discussion of piercing corporate veils because I've seen it in a case I was involved in. I would urge caution on that because, as we all know, the Supreme Court looked at the issue of corporate veils, I think, some 7 years ago now. And even if there is such an ability to pierce a corporate veil, it's absolutely obvious that one is having to look at fraud. And I don't think that there's any suggestion here that could be made out on these type of structures. More importantly, I think, and more relevant and more likely to crop up, is going to be the issue of sham tenancies or sham agency agreements. I've already seen this cropping up in a few cases, and I think it's going to be really the focus of a lot of attention over the coming months in terms of trying to understand whether the tenancy structures are what they appear to be. First of all, obviously, do we have agents involved? And in particular there, we have these issues of guaranteed rent agreements, which themselves are always a bit of a headache. And many people don't often really understand the difference between agencies and tenancies. But there is also, I'm sure, going to be an issue of whether landlords are using structures, as I say, to distance themselves. So the first thing there is those who are advising landlords, agents, or even tenants need to be really up on their drafting and actually thinking about what exactly are the legal relationships here. And I've already seen in 2 cases issues of applications being made for disclosure of agreements and other documents relating to how those agreements came about. And in the tribunal rules, we're looking there at rules 6, 7, and 18. The next thing to say, and this is very clear, is that the Court of Appeal are not willing, in this case, to entertain policy concerns. What you might describe as the rogue landlord policy drivers are simply not going to be relevant going forward. What we have is a much more traditional approach to statutory interpretation. And in fact, Lady Justice Andrews actually comments on this, and she says that sometimes it's correct to trust one's first instincts in reading a piece of legal text, in this case a statute. And she actually says that in her view, that's where the upper tribunal went wrong in Rakusen and Jepson, that they didn't trust their first instincts in terms of actually simply reading the black letter law and forming a clear view on what it meant. And I think there is clearly a suggestion from both of these judges' judgments that there may be some confusion being caused by consideration of policy concerns and all of this issue of regulating the housing market. So I would say to anybody advising clients on this, going forward, look at the law, simply read the law as it is, and don't try and give great prominence to policy drivers or policy concerns. Those arguments have now pretty much been put to one side. And I think you'll be on much safer ground if you're advising clients by simply doing an old-fashioned job of analysing a piece of statute or regulation on the page. So I would say that certainly if you're going to have a decision which comes up, which is based on anything that looks like policy, then you might be wanting to appeal that. And likewise, if you're thinking of appealing something and using as your main ground policy, I think certainly it looks as though the Court of Appeal are not going to entertain it, certainly in the field of rent repayment orders. And the final comment is, of course, that as Lord Justice Arnold said, it may well be that in due course Parliament will amend this situation. And there clearly one is looking at issues of policy, rent repayment order, and whether effectively this case has drawn the teeth out of the entire rent repayment order system. So I don't have anybody to hand over to now. So I believe that I now need to invite our moderator and all my colleagues to come back onto the screen. And I think that we actually have a fresh moderator, which is Claire, who's our Chambers Director, but is also formerly a partner at Anthony Gold. So she's our bridge person, so to speak. And I think that we have now maybe any questions or even comments, I think, because I know that we have, looking at the attendance list, a lot of very, very experienced and involved people on this webinar. So I think we'd all be interested to hear what other people have to say. And I think there's a few names there that I recognise from my own cases recently. So it'll be interesting to see what people think. Claire.
Thanks, Archie. Yeah, we've got quite a few questions that have come in. So if I read them out just one by one, and then whoever wishes to answer can answer. And if none of you volunteer, I'll just choose one of you. So the first one is regarding HMO management regulations and Regulation 10 and tenants restricting access, in that tenants cannot obstruct access to all common parts and only into exclusive rooms occupied. So surely cannot provide a defence to any offences apart from possible offences related to a specific room? Dale?
Thank you. I think the question is prefaced on the fact or an assumption that tenants can't obstruct access to all common parts. Well, it would certainly depend, and I think it would be very fact specific depending on the makeup of each specific HMO, because I think there would be circumstances where tenants can obstruct access to common parts. If one thinks of a typical HMO that consists of, let's say, a 6-bedroom house, and you have circumstances where all the tenants work and you've got one tenant that's volunteering in a way to stay in during the day to grant access, and then that tenant deliberately doesn't let the landlord have access at pre-arranged times, then that tenant would be obstructing access. So I think there are situations that could give rise to one tenant obstructing access to common parts. But in terms of the remainder of the question, exclusive rooms, yes. I mean, in the same makeup of a HMO, if those tenants all have their own individual rooms and let's say they have locks on, let's say one of the tenants' windows are broken, which would be a breach of one of the management regulations, and that tenant failed to let the landlord into their room so that they could get access to the window, then yes, that tenant would be obstructing access to that specific room. And I think in that circumstance, it would be a defence to the landlord. It could be a defence to the landlord if that access was not being granted. So I really think it's very fact specific. There are so many different scenarios that I can think of, but hopefully I've done my best to answer that as well as I can.
Thank you. Okay, the second question then. If a landlord has submitted a licence application, but there's a delay with the council in granting it, can the landlord serve a valid Section 21 notice?
I can answer that if nobody else wants to. The short answer is yes. They can serve a valid Section 21 notice. The slightly longer answer comes down to analysis of the statute, because it's Section 75 of the Housing Act which says that a Section 21 notice can't be given if you've got an unlicensed HMO, but subsection 2 of the same tells us that unlicensed HMO has the same meaning as in Section 73. And if one goes to Section 73, it's not an unlicensed HMO within that definition if there's been an application for a license and that application is still effective, i.e. that application hasn't been disposed of. So if there's an outstanding application for a license, it's not an unlicensed HMO within the definition, and therefore a Section 21 notice can be validly served.
Thank you. Do you think corporate landlords with substantial property portfolios will be held to a different standard than small landlords regarding reasonable excuse? Why or why not? Archie, do you want to answer that?
I think the question probably has the answer in it. I think the answer is probably going to be yes, because if we look at the sort of matters which Robin discussed, the sort of factors which may chime, and also if we think about, comments made by tribunals in RRO cases when they've been looking at aggravating and mitigating factors, and in fact in a number of other areas, the scale of the holding by the landlord to an extent gives a sort of a degree of greater knowledge or professionalism. I think it's almost inevitable that, I mean, if one thinks, for example, about civil penalty notices, the civil penalty notice regime, most local authorities in their policies, their guidance, which they have to have, and their charging matrices, which they have, where you work out how much of the charge there should be, a lot of them have included in that a stage which takes into account the scale of the landlord, and it'll be on sort of banded by 1 or 2, sometimes 5 or 6, and then upwards. And it's inevitable that a bigger landlord is going to incur a higher standard in effect, and that's, I suppose, inevitable, but it's also a question of a sort of policy driver. In reality, as we know in the real world, it doesn't follow at all that landlords can have dozens of properties and often are not really in control of their portfolios properly, and you can have individual landlords who sort of, this awful phrase, accidental or amateur landlords, but who are actually excellent landlords. They're giving a bespoke service, they really take care, and they actually have an excellent relationship with their property and with their tenants. So yes, I mean, although it doesn't really actually tell you anything, I think that higher standards are going to be expected of bigger portfolios. Although the irony is that the larger the portfolio often creates the same problems, with landlords running around not putting the resources in. This is the point. I totally agree with Dale. You know, active, proactive management of houses in multiple occupation is what is required, and that costs resources, and that in the end costs money and time. And landlords with more than a few properties really should be managing their properties in that way, because otherwise they're going to walk into liability. Yeah, and I think they must expect to be held to higher standards if they have more.
Just to add, sorry, to add to what Archie said, in the case which Dale mentioned, Williams and Parmar, in a discussion about quantum for RROs, the upper tribunal talks about professional landlords, and there's obviously a sense in which any landlord is making money. They're all professionals. No one is really an amateur, even though that phrase kicks around, as Archie said. But in that context, a professional landlord is picked out as a marker for someone who would be likely to have a higher award for an RRO. So that's about the size of an award, not whether or not there's a reasonable excuse, but it's definitely in play there as well.
I mean, I think that on this issue of reasonable excuse, quite clearly, if you look at the cases that Robin took us through earlier, where you've got this issue of landlord ignorance, of not understanding the obligations, you know, it's not really actually going to have that much traction unless you've got a really clear-cut reason, like the lady who was told by the local authority, we'll tell you if you need to license it. We've all had one or two cases where you get this kind of result, but they're pretty rare. And I think I would urge caution on anybody really thinking that reasonable excuse can work. It's an extremely hard defense in practical terms to make out. And I think any landlord who is anything like, as Robin said, in a sort of professional category, you can just forget it, because for policy reasons, the courts are just not going to wear it. Much higher standards are expected. You know, if you've got one amateur landlord and she's got, you know, an agent in place who doesn't do his job, or she's told something by the local authority, you might have a runner, but it's difficult. It's very difficult to persuade courts of this. Thank you. Tribunals.
There's a follow-up question that's come in about reasonable excuse, actually, or a second question. So we'll go through that now, which says, in relation to reasonable excuse defence, could the presenters give their views on how often they would expect landlords to inspect their properties to ensure it's not operating as an HMO without their knowledge? Also, what other steps or actions they would expect the landlord to have taken in order to have the reasonable excuse defence available to them? But I think what you've just said, Archie, is that it's unlikely to be available very often.
I think all I would say is it's very fact specific, like all these defences are to strict liability offences. And you know, you really have to clearly make it out. My experience is, you know, as an advocate, is, I don't know if my colleagues feel the same way, but whether it's used as a defence to a simple, straightforward prosecution in the Magistrates' Court under the Housing Act, or whether one's trying to use it in, you know, for the underlying alleged offences in RRO or civil penalty type situations, it is always difficult to make out. You've got to have a very persuasive case. And I think in terms of what is being raised here, sorry, the question, Claire, was again,
about how often you would have to,
okay,
how often you'd be expected to inspect a property.
Dale and I have discussed this in chambers, just as a passing thing. I mean, my view is to be on the safe side. I would pretty much say you should probably be going around at least every month or two, really. You certainly shouldn't be leaving it 6 months. Absolutely not 6 months. That's far, far too long. And the reality is it depends on the property. you can't put down a hard and fast rule because you can't. I mean, some properties have a much higher turnover. It depends on the HMO, like Dale said. If you have, that classic phrase, cohesive living, which has cropped up in another context in connection with HMOs. If you're looking at that, where you might have, say, a student house where they're going to take the house for a whole year, you're probably going to have stability there. And so you might find that the house, if it's standard statutory licensing, so you're looking at you need 5 people before you hit the licensing requirement, for example. Probably going to be able to say, well, I've let it to 4 students, and therefore, if I'm in a basic licensing area, there aren't going to move any extra people in. Who knows? Someone might move their partner in or whatever. You just don't know. But where you've got another type of HMO, where perhaps you've got casual workers who are coming through a town because they're doing seasonal work or they're doing project work, on a piece of, it could be like building the high-speed railway or something. There's all kinds of people who are needing short-term accommodation. That's often provided in HMOs, but they often don't hang around because their jobs or their lives take them on somewhere else. Agricultural work, for example, is the other classic example of places like Lincolnshire. You can find very high unstable turnovers of occupants of rooms in HMOs. And so often landlords really have to keep a much closer watch on those type of properties, because they're just much more fluid because of the nature of the occupants. I would say, look at the type of property you've got. Always, ask the local authority. I mean, as I say, don't ask if you don't want to get the wrong advice, but if you don't want to hear something you don't want to hear. But basically, the advice has to be ask the local authority. And I would say at least every month. I mean, if you're going to be safe, I would say every month. And some managing agents will offer that anyway. But anything less frequent than that, you're going to be taking a risk, I think, because it's very difficult to argue. I mean, I've argued successfully reasonable excuse for something like breach of management regs or failure to license if it was a regular inspection regime. And the other one is keep records. It is not enough to simply then, when you're prosecuted or you've got, an RRO being made or a civil penalty that you're being hit with, to then produce a witness statement and say, yeah, well, we go around every month. But, anybody can say that. And I think tribunals are going to want to see corroboration and a system. So keep records, a notebook, a log, whatever, because in the end, it may save you tens and tens of thousands of pounds or a criminal record. So it's a small thing to do. And actually, it's the right way to manage property. If you're a landlord or an agent, you're providing someone's home, and you should be in the business of providing decent standards. And that means that, with an HMO, you've got to do that. It's your job, not the tenants. They don't have a responsibility to report it. It's not like Section 11 on a single let. So you should be in there checking that the property is warm and dry and the services are working and that everything's fine. It's a totally different deal, this. And so it's not a question of using the inspection regime to avoid liability. It's more a question of simply doing the job properly, I think, to be honest. And that's what the courts will expect. If you're showing that you're doing the job properly and then something goes wrong, you're going to have a ready-made defense. So it's more about thinking about it in that way, I think, rather than looking to have a manufactured excuse you can put off the shelf.
Archie, I don't want to stop you, but we've got quite a few questions coming in. So can I move you? That's okay. I'm not sure if we can answer this next one, but maybe someone can tell me if we can. Where would an agent stand if the local authority say planning is needed, but the relevant planning department says planning isn't needed, and then it says Tower Hamlets? So I assume Tower Hamlets are the problem rather than the question coming from Tower Hamlets.
Consult your lawyers, because it sounds like there's some quite important documents that they would want to see before really advising on that. The days of planning and licensing being completely different regimes that have no interaction with each other are over. the upper tribunal says that licensing decisions can take into account planning, but clearly something's gone wrong there. Maybe it just needs some stern letters, because it sounds like people aren't really talking to each other.
Fine, thank you. So I'll go on to the next one, which says, does a local authority actually need a documented enforcement policy? Is it sufficient to simply refer to the regulator's code in carrying out enforcement functions? Archie, do you know the answer to that?
Well, I mean, local authorities do definitely have to have a policy, an adopted policy and guidance for civil penalty notices. That is clear from the central government statutory guidance. So, and if they haven't got one, then they're in trouble. But they almost all, I think they all have one now. I've come across one authority where they were very reticent to hand it over. We couldn't get hold of it, and we suspected they hadn't got it, and they were very sheepish. But in terms of enforcement policies per se, I don't know is the answer, actually, because I've never had to think about whether they need one. I mean, it would be best practice to have one. Often what you find is that you've got, I mean, I assume we're talking about enforcement under the regs, enforcement of the management regs. I don't know, Robin, have you ever come across this issue?
Some councils have very generic enforcement policies which cover everything from fly tipping to parking to housing, and that can create problems. I don't see any reason for it. It's so easy to simply go and choose your favourite enforcement policy from a neighbouring borough and photocopy it. So I don't really see any good reason to not have one when plagiarism is so easy.
I think the straightforward answer is no. I don't think they do have to have an enforcement policy per se. But most of them, as Robin said, you will find something that they will have sort of adopted it, and it may be part of their general enforcement for their general duties. But I don't think they do, as I say, except on the civil penalty notice regime, where they do have to have a policy, and some of them are quite lengthy.
Okay, well, the next question starts with the words, "Hi, Robin." So, Robin, I assume this is for you, but don't worry, because Archie, I think, has answered half of it. It says, we are licence holders for many of our overseas landlords. Can we charge a higher management fee? And should we be visiting the properties on a quarterly basis? Thank you. So I think the answer to the second part is really Archie wants you to go monthly. But what about the fee, Robin?
As Archie was saying, you're taking on a big job, and you should get paid for that. You should get paid for the work, and you should be paid for the risk, frankly. What the license specifies as what you are required to do for inspections is the minimum, the absolute minimum. Archie makes a compelling case to go a lot more often. Obviously, you want to be paid for that, and you should be. So I don't see why you shouldn't be charging for that. I can see an issue if you're planning to charge more to your overseas landlords than your UK landlords. That might have some issues there. Is there really a good reason why you would be charging an overseas landlord more than a landlord based in Shetland? I suspect not. So that's something to think about. But absolutely, that you're providing a risky and premium service, so you should be charging accordingly.
Thank you. So the next one, given tenants are unable to claim RROs from agents, then wouldn't the ability of landlords to successfully blame agents render RROs meaningless?
Dale, it's probably Dale.
I think Robin dealt with blaming the agents, did he not?
I'll have a go at this, but I think it's worth Archie and Dale chipping in on, because I think that's really interesting, and it gets into what RROs really are for and what they're about. I think they're more like a private prosecution, a prosecution brought by an individual, than they are a consumer remedy. And in Ficara and James, the deputy president of the Lands Chamber, said that they're not compensatory in nature. It's punitive, and so yes, it's not great for a tenant if their claim fails for some because of the actions of some third party. And the Da Costa case, where it's the local authority advice that was wrong, that's what deprived the tenants of a rent repayment order. Nothing that they did wrong, but it's just a function of the fact that RROs are there to deter landlords from breaking the law, not to compensate tenants. And so if that's what we want to have, the law needs to be changed to provide for that.
I mean, I agree with Robin. I think that the whole RRO regime, you can either say it's a very clever way of effectively getting tenants to be involved in helping to regulate the private lettings market at the sort of lower end of the market where the problems tend to come. So effectively, you're recruiting lots and lots of sort of EHOs, amateur environmental health officers, to go around and keep an eye on all the landlords in your borough. And you're incentivizing them by giving them a very substantial financial incentive. But you know, you could take that view, or you could take the other view that it's a complete hodgepodge of mixing up, you know, a sort of private law compensatory frame of mind into something that is really to do with regulatory enforcement. It's probably a bit of both, actually. I mean, on the one hand, it's a rather clever scheme for local authorities which now have very few resources and a huge amount of a very, very complex housing issues to contend with in the private rented sector in places like the big cities. But on the other hand, it's yeah, what can one say? Yeah, I agree. It's very interesting development, RROs, but they don't expect any of it to make any particular logical sense. So yes, you can get situations where what would work as a criminal defence appears to be unfair to a tenant, but I think tenants have to understand they're in effect being employed to carry out housing regulation, so that to scare landlords in there and others into making sure the properties are properly managed, basically.
Archie, this one probably runs on from that a little bit. Could the subordinate tenant who let the flat as an HMO have applied for an RRO against the superior landlord for the rents they had paid for the 3-year lease in Rakusen and Jepson?
No, because the word regime is to do, well, unless Dale tells me I've misunderstood the statute, or Robin. It's, oh, sorry, no, because
I've been toying with this. I don't think anything very. I mean, not actually. I don't have one up my sleeve to run. I don't think the legislation very clearly rules it out, because you have to be a tenant of housing, and housing means a dwelling. As I read the legislation, nothing expressly says you have to be an actual occupier to bring the claim, but the tribunal does have a general discretion not to make an RRO if it doesn't want to. Yeah. And I suspect that's probably how they would stop this, even if they accepted that the law in theory allows it.
It's an interesting one, because if you could do that, I can foresee scenarios where, let's say, the tenants bring a claim against the immediate landlord for an RRO, and then the immediate landlord joins in the superior landlord on the basis that they're then seeking an RRO from them, so that they could just pass it directly to the superior landlord through a chain in a way. But I don't know the answer. I'd need to. I think, Robin, you might be right. I don't think it's as clear cut. I don't think there's anything that would exclude it off the top of my head. But I think we'd have to get into some very detailed statutory interpretation, and I don't have all the provisions in front of me to do so, and I don't know off the top of my head. But it's a very interesting point that's raised.
There is a follow-up point to that, which is that, so let me go through the whole thing. Could the subordinate tenant who let the flat as an HMO have applied for an RRO against the superior landlord for the rents they'd paid for the 3-year lease in Rakusen and Jepson, in that the superior landlord willingly and knowingly permitted the subordinate landlord to commit the offence of creating a licensable HMO and provided no provision that they license it, hence could have been guilty of the offence of failing to license. Does that make a difference to your answers?
So I'd have to work out how that would work. I have to go back to first basics because you have to look at a few bits of moving law there at once. So you're effectively going to say that a Section 72 offence is being committed by the superior landlord on the basis that they have a licensable property. Yeah, I mean, person having control or person managing, I suppose, they would be within the scope of liability for a Section 72 offence. And are they, yeah, they're person having control. I mean, yeah, yes, I suppose, person having control of a licensable property that didn't have a license, because the offence is having control, not the failure to have a license. It's, you know, as the courts have made clear. So I've just never come across it. I mean, it doesn't mean it won't occur.
There's no doubt that the superior landlord would be committing the offence.
Yeah.
That's still fine. It's just whether the sort of intermediate landlord can bring a claim against the superior landlord for an RRO. I think that's the interesting point that arises.
It's difficult to imagine if the sort of person in the middle layer has also committed an offence. It's quite difficult to imagine persuading a judge that that person should be able to make money out of the situation by getting a rent repayment order themselves. It's quite difficult to imagine persuading a judge that that was a fair outcome.
And certainly, Robin, in terms of Parma now, that we know that you know, it's open season in terms of being able to argue actions by all the parties in terms of assessing the final amount. You could end up with, as you had in one of your cases you were talking about, you know, a nil award. I mean, you know, because Williams and Palmer has taken off the shackles from the first tier tribunal. And I had a decision only a week ago where, you know, we lost on liability, but Judge Robert Latham slashed the award by half. And so my client had a half win, and specifically because he correctly applied what was now the new Williams and Palmer rubric. So, yeah, I hadn't thought about that. I mean, I suppose if you were a rent-to-rent intermediate landlord and you did find yourself in a situation where there was an actionable offence and you wanted to chance your arm, I suppose you could have a go at getting a rent repayment order from the landlord, your own landlord, further up. I mean, obviously you can only go one stage now, immediate. I've never heard of such a thing. I mean, it would.
Should we move on a little bit, because it's just gone 6 and there are a couple more questions to go through. Let's try and, this next one is a bit, I think has got an easier answer, hopefully. So is it the immediate landlord that should also be held responsible for complying with the HMO management regulations?
Well, the management regulations, specifically the liability lies with the person managing. Okay. And that's section 2633 of the Housing Act 2004. And that is the person who, well, it is always been understood that I know there are those who are waiting for the test case to argue about what that subsection means, but it's been understood that that is to do with the landlord or the agent of the landlord, who is the landlord of the actual occupiers, the residential occupiers. So the liability lies with the person managing, and that is the actual landlord of the actual tenants who live in the property as their home. There is an argument, which one day will crop up, I'm sure, because we're all aware of it, to do with the understanding of the statutory language, that you could then make that definition wider. I've seen it toyed with as a sort of obiter element in sort of tribunal type situations, but I think everybody's too scared of what the implications would be, because it would effectively then put the management regs into it would extend their liability to persons having control in effect. And I don't think anybody wants to think about the consequences of that, because it would confuse matters. So the answer is management regs is the immediate landlord or their agent, because the test is receipt of money, and the money passes through the hands of an agent into the principal, who is the landlord. Sorry, does that make sense?
That's okay. We've got a few more questions here. I think I'll do one or two more, and then we might have to answer the others some other way. Let me see if I can just rush through them. If a landlord has been running an HMO either knowingly or unknowingly without a license, and also claiming the tenants are their friends who just contribute money towards the bills, can the so-called friends claim a rent repayment?
Don't see why.
Good friends.
Don't see why not.
Yes.
Because if what you, as I said, look at the arrangement. If what you actually have is a tenancy, and then we're looking at all the well-established law about, you know, what a tenancy is. Why not? Why not? Yeah, I mean, it looks like rent repayment orders are incentivizing all kinds of people to turn on all kinds of other people, and the whole become a bit, you know, a bit of a free-for-all. But in theory, yes, there's no reason why not.
I would say think carefully about
sorry.
I was going to say think carefully about the lodger exceptions from licensing, which may or may not apply depending on the circumstances.
Yeah, I mean, the issue there, yes, there is that. The issue there, of course, I think would be the issue of underlying liability for the Section 72 offence, or the other type of licensing offences.
I'm going to do this next one as the last one then, I think, which is a sort of two-part question. To clarify on the issue of reasonable excuse against quantum, would a large landlord be less likely to, for example, blame the agent as reasonable excuse for failure to license than a small landlord? I'm not sure about that. I think the answer that we got earlier was that a large landlord is probably going to be held to a slightly higher standard. So I'm not sure that I'm not sure the question is really whether they would be less likely to blame someone as whether they would be less likely to get away with it. Presumably a large professional landlord is less likely to get away with blaming the agent than possibly a small one might be.
Yeah, I mean, I always say to landlords, unfortunately, you have to manage your managing agent, if that makes sense, if that's not tautology. You know, you do have to keep an eye on those who are doing work for you. There are a lot of agents out there who are very good, and there's a lot of agents out there, in my experience, who are not so good and can end up putting their landlords into all kinds of difficulty. I think Claire's entirely right. The question is really not whether you would blame them. At the end of the day, if you're in a tight corner, a landlord will often reach for, well, the whole purpose of this talk, which is to seek to shift blame or find an explanation. The question is it real? Does it work? Will it work in court? Because if an agent has really gone on a frolic of their own and caused all kinds of problems, a landlord, it seems to me, would be totally entitled to say, I've really been let down. Whether it will work, it's fact specific, isn't it? Depends on the tribunal.
It's
well,
definitely
that
very.
Goes to the next. Sorry, go on,
I was
Dale.
just going to say very briefly. It's definitely very fact specific, but there may be circumstances where you've got a very small landlord that you know, you may want to resort to sympathy insofar as getting sympathy from the tribunal, and one never wants to have to resort to that. But sometimes with a smaller landlord, perhaps blaming the agent, there could be an element of sympathy which could get a reasonable excuse defence home. If you've got a much bigger landlord, you're not going to get that sympathy. It's just not going to work, as Archie has said. So I think that's the only other perhaps factor to take into account there.
And what I would say,
and I think there was sort of a follow-up which talks about landlords dodging HMO licensing obligations by hiring agents willing to overlook it. But I think that it seems to me that that is not going to work.
No, it's not going to work. I mean, there is no way around this. At the end of the day, the private rented sector, particularly HMOs at the HMO end, is heavily regulated. It's how all of us are living, because the law is now really intrusive into the market, because there are perceived weaknesses and problems and risks for tenants and for, you know, society as a whole. So there's a lot of regulation. And that regulation is enforced, and one of the ways it's enforced is by co-opting tenants by incentivizing them with large cash offers, by incentivizing them to effectively report on their landlords. And so, you know, being a landlord in the HMO world it's tricky, and you've got to make sure your agents know what they're doing. You've got to manage your agents. You've got to make sure the properties are being inspected. But on the other hand, you know, as bad landlords are squeezed out or find themselves subject to enormous financial penalties, you know, you can get a year's rent can be, as I say, £40,000 just for a 3 or 4 bedroom property. Plus, you can end up with maybe a civil penalty, as one of my clients has at the moment, which can be another 25,000. You know, you're looking at huge financial risks here, but good landlords are going to benefit from that, because good landlords are simply going to survive and they're going to prosper. So it's like any regulated business, you know, you've just got to be on top of your compliance, and always ask the local authority. If you're not certain, ask. My experience of local authority officers is that, you know, they're overworked, but they will try and help, by and large anyway. There are exceptions, but that, yeah, go and get advice. Just do the right thing, and don't rely on someone else to do it for you. You can't always trust your agent to doing the right thing, and absolutely don't try and game the system, because in the end, with tenants being incentivized, you will get caught short, and then it can be literally cripplingly expensive.
Okay, very, very last question. It says, what about the clean hands of the lowest landlord?
What does that mean?
Okay. I think we better stop in that case.
Well, I think I know what they're getting at. The clean hands. Well, but there's no such thing as clean hands, because the Housing Act places responsibility on people involved in letting property or managing property or being agents for it. It's not a question of, as Robin said, there's no mens rea on this. These are strict liability scenarios. There are duties, and you have to discharge those duties. And it's not that you set out to break the law or that you intend to do it. It's that you just are not meeting the standards required. So the only way to have clean hands is to follow the rules, really, I'm afraid. But then if they all did that, we'd all be out of work, wouldn't we, guys? So, I mean, I don't want to sound cynical, but yeah, basically just do the right thing. Down, ask for advice.
That's brilliant. Thank you all very, very much. Thank you everyone for attending. The final comment that's here says, more a comment. Mr. Madden's summary of the Court of Appeal in Rakusen and Jepson was very good, clear and accurate. So that's a nice note to leave us on. And thank you very much everyone for attending. You'll be able to watch us back on YouTube, I understand.